today we appeared, all 23 of the various Hudson River protectors appeared in Cortland Town Justice Court. And there are three separate cases, one having to do with a demonstration that occurred on October 10th, Indigenous Persons Day back last year. Another happened in late November, and another one in early December. Each of those cases was adjourned. Each of those cases is in the midst of further motion practice. The case involving the first group from October 10th, we're still seeking to get a judge's decision on a speedy trial violation. We're arguing that 4 of the 7 people charged that day, their case should be dismissed for a failure to secure a speedy trial under the New York State statute. It has to do with the fact that it's a B misdemeanor. It's only 60 days of time that they can waste on that on a B misdemeanor case, and we're arguing that they've gone past the 60 days. On the second case involving 4 folks who were charged in mid to late November of 2016, we have filed a speedy trial motion in that case, which applies to 3 of the 4 defendants. One of them only just was arraigned, so she doesn't get the benefit of all the time charged, but the other 3, we believe, again, are entitled to a speedy trial, and on a B misdemeanor, the 60 days has expired. On the last 12, that case is a more recent case, a slightly more serious case, and we're still making motions to dismiss 2 of the 4 counts charged against these folks, the resisting arrest count and the obstruction of governmental administration count.
What are the other 2?
The other 2 are trespass charges, one of which is a B misdemeanor, the other one is a non-criminal violation. And we're saying in our motion that passive resistance, meaning the classic sort of conduct of demonstrators of going limp and not assisting in their own arrest, does not constitute resisting arrest under the law or obstruction of governmental administration. Under case law, to constitute resisting arrest, there has to be some attempt to prevent arrest, whereas the only thing you could say about my clients is that, assuming they could prove what they did, that they sought to delay their arrest or make their arrest less convenient to the police, but not actually prevent it, because that was going to happen anyway. They were inevitably going to be arrested. Similarly, with obstruction of governmental administration, the law says that interference with governmental administration has to be physical interference, and that, again, going limp and not assisting in your own arrest doesn't constitute with physical interference the way the legislature contemplated when they enacted that statute. Physical interference would require like assault of conduct, or like chaining yourself to like a fence, or doing something else that literally physically interferes with the police in doing something that the police are entitled to do. Just going limp doesn't interfere with it. Again, just makes it more more difficult. And again, we have case law that's goes to that as well. So I think we have a pretty good shot of kicking out the top 2 counts against the Protector 12, the group from early December. And then we'll see where we stand with a complaint that is considerably less serious.
Water is life! Agua es vida! Mi name is Shani!
Keep it in the
Save our
ground.
water!
Death to all snakes.